Hello and a good day to Mr. Justin, our lecturer. Today we'll be presenting regarding the critical analysis of media freedom laws. Our group consists of Aqil, Soveena, Kayshana, and myself. Now, before moving on to the presentation, I will be laying out the table of contents, which was first, we will do the introduction of the laws we will be covering. Secondly, we will move on to the 5 laws that we have chosen, which is the first one, Official Secrets Act, following by the Sedition Act and Defamation Act, and as well as Printing Presses and Publication Acts and Communication and Multimedia Act. The presentation will be ended with a conclusion. Now, introduction. So, as a group, we collectively discussed and decided that we will be choosing these 5 laws, as stated earlier, which again, the first one, Official Secrets Act 1972, secondly, the Sedition Act 1948, the Defamation Act, Printing Presses and Publications Act 1994, and lastly, the Communication and Multimedia Act. Now, for the first law, which is Official Secrets Act 1972. The Official Secrets Act 1972 is a law prohibiting disclosure of information known as an official secret in Malaysia. The Act describes an official secret as any record defined in the schedule and any information and material relating to it. It includes any other official paper, information, and material that may be designated as top secret, secret, confidential, or restricted. As the case may be, a governor, the Menteri Besar or chief minister of the state, or other public officers can implement this documentation. It was revised in 1986 after the act was criticized for lacking clarification. So an example of this case would be Rafizi Ramli. Rafizi Ramli is a PKR vice president, and back in 2016, Rafizi Ramli was detained in front of the parliament by the police where he would be investigated under Section 8 of the Official Secret Act. Further confirmation explained that Rafizi Ramli was alleged of distributing a page of the Auditor General's 1MDB report in his website. After the proceedings, he was initially sentenced to an 18-month jail sentence, but was substituted with a 2-year good behavior bond by the Court of Appeal, as during that time, 1MDB report was declassified in 2017. So we collectively agree that the OSA should be more transparent and the government should take a proactive step in ensuring better systems are implemented when categorizing such documents. The reasoning behind this is that the public has a right to be informed regarding such issues happening in the country, and they should be aware of which documents can be categorized as a threat to national security and vice versa. We believe that if the government pursues a stricter policy for the OSA, it will be a form of oppression for journalists and media freedom, as well as for whistleblowers, as it hinders the narrative of freedom of information in Malaysia. Freedom information, as we all know, is central to democratic participations. If we do not know what the government is doing, we cannot participate in decision making that affects us or even really exercise our right to vote in an informed manner. But the right to information is also important for accountability and to root out corruption in Malaysia itself. We also believe that the public's interest should be prioritized, even right now in the current state, as the public has a demand for greater transparency in the age of information.
Moving on from OSA, now we'll be talking about the Defamation Act of 1957. So defamation can be defined as a statement that is published or broadcasted that can damage a person's reputation. So in Malaysia, civil defamation cases are governed by the Defamation Act of 1957, while criminal cases fall under Section 499 of the Penal Code. Under common law, defamation is branched out into 2 types, which are libel and slander. So libel is a permanent form of defamation, such as newspapers or books, and slander is a temporary form of defamation, such as spoken words. On 9th June 2007, the head of the MCA Public Service Complaints Department, Dato Michael Chong, filed a defamation suit against Chinese Daily's publisher and chief editor, Guanming Ribao, and Shang Li Shuang for issuing an article that allegedly mentioned him as the Along King. So the plaintiff stated that the article issued on December 8, 2007 suggested that he was encouraging unlicensed monetary loans. The article also suggested that he was a criminal and he was untrustworthy. So due to this article, Chong was humiliated and despised by his friends, the political associations, and the community members. This also led him to being summoned by the president of the MCA to explain the alleged act of unlicensed money lending. Not only did Michael Chong file an injunction to hinder the defendants from issuing these claims again, but he also requested an apology to be issued on all media which had included these negative claims. In our opinion, the defamation laws in Malaysia are far too severe, and to ensure a community that is united and fair, these laws should be improved with more protection towards the party who has these claims against them. Individuals who have made these claims of defamation also have to provide proof of serious harm that they have endured before suing the other party. We strongly believe that there should be more protection towards journalists, scientists, and academics who publish this material that is peer-reviewed or public interest.
Apart from defamation, another law that we also discussed was Sedition Act 1948. This Sedition Act was originally enacted by colonial authorities of British Malaya in 1948. In Malaysia, when someone is involved in an offence that involves Sedition Act 1948, they are usually being asked to pay 5,000 and below ringgit to be out of it or be in jail for about 3 years and below, or either both of it. So let's discuss about a case that's involving Sedition Act 1948 in the year 2014. In the year 2014, on the 3rd June of 2014, Dato Sri Najib Tun Razak filed a libel suit against MalaysiaKini.com and two of their chief editors, which is Mr. Sivan Gan and Fatin Omar. The reason behind this suit was because of the seditious words regarding a political crisis in Terengganu was mentioned in their website portal under their Your Says column. Dato Sri Najib Tun Razak and his political party UMNO initially requested for an apology post and to get that particular column deleted, but instead Malaysia Kini posted about the threat and mentioned that they were not going to apologize for the mistake. Because of the seditious words that was mentioned in that column, it made Datuk Najib Razak and his political party to seem like they were a not really good leader and immoral political party. In conclusion, our group thinks that harsher penalty should be given to those that involved in seditious act, because this will be a life lesson to those who actually are in the online media, and they will be much more mindful on what to post in the near future. Hence, there should be harsher penalty given to these people who have been involved in seditious act.
Moving on from the Sedition Act, the other law that me and my groupmates chose to amend is the Printing Presses and Publications Act 1984, which is short for PPPA, which is commonly referred to as Act 301. which was initially introduced by the British colonial government to combat against communist practices, which are perceived as a threat or menace to the government. So this law had disclosed that all printing presses must obtain a license that is specially granted by the Home Affairs Ministers, and those who do not own a license will be prohibited from printing or publishing any content to the public. Moreover, the Home Affairs Minister has the authority to revoke or suspend a license if they were to discover any criminal offense that can be found on the print itself. So this law drastically affects the freedom of press and liberty as it prohibits the people or the media to voice out their opinion or information to the public even when they have valid proof regarding their publications. So moving on to the next slide, you may question yourself as to who this person is. So this person goes by the name of Zulkifli Anwar, which is also short for, his nickname is, people refer to him as Zunar as well, which is his cartoon nickname. And so basically his story is, back in 2010, a famous political cartoonist who goes by the name Zunar, as previously mentioned, he was severely punished as the police had arrested him prior to his official book launch and seized multiple piles of copies of his book and had all his previous work that he produced and published banned. And the reason behind his arrest was because he was accused of violating the country's repressive sedition act, as the book he intended to publish may have or could have instilled hatred, misunderstanding, confusion, and the loss of trust in the minds and hearts of the citizens. So the group had come to a conclusion that PPPA should loosen the guidelines for any printing presses to publish their content, as the law is too strict, as it prohibits the media's ability to influence people's mind to go against the government or country's agendas. So, and other than that, we also collectively agreed that the law should allow the printing presses to publish news, articles, journals without any form of restriction when valid information of proof is present. So when the media presents a letter of proof or approval letter, then they should not be restricted from presenting or publishing any news to the world for the world to see. And when it comes to suspending or revoking licenses, the Home Ministry has to justify their judgment when it comes to suspending a printing press. So when the Home Ministry wants to revoke or suspend the media's license, they have to provide a valid reasons as to why valid reason as well, which is also known as a valid judgment as to why they want to suspend a printing press. Moving on from PPPA, the last and final act that the group chose to cover is the Communication and Multimedia Act 1998. It is also short for CMA. So what it generally means is that the Communications and Multimedia Commission Act 1998 acts as a regulator for the communications and multimedia industry in Malaysia. And the act basically covers everything that is related to electronic communication devices, such as radio, television, internet, and many other communications and networking devices. And the act also offers a legislative obligation to protect a free and open internet. And other than that, the act also exists to assist in merging telecommunication, broadcasting, as well as computing. And the case that we decided to choose, which relates back to this act, is this person right here, who goes by the name of Fahmi Reza, who happens to be a political graphic designer. And his case occurred back in 2019. So back in 2019, a human rights defender and artist who goes by the name Fahmi Reza, he actively creates cartoons to promote and increase awareness of human rights. But he was brought to court and was accused of malicious intent for posting an illustration of the former prime minister and characterized him as a clown on Facebook back in February 2016. And you can see by the images that I have placed here, the artist and his drawings of our former prime minister. And according to Malay Mail back in 2017, the CMA Act was found to be heavily misused and abused by the government. And a man who goes by the name George Barugis, who is a Malaysian Bar Vice President, had come out with a statement saying that he urges the government to stop abusing the act at will. And he also mentioned that the right to freedom of information, freedom of liberty, opinion, and thought belong to every single citizen, and having them taken away from the citizens actually acts as a threat to silence each and every single one of us. And we as a group collectively agreed that amendments have to be made and implemented for CMA, as this act is far too broad and needs to be straightened and tightened immediately to eliminate the existence of such abuse in a law, in a particular law, which is CMA, and provide fairness to the public and multimedia for them to share or spread anything out of their mind, out of thoughts and feelings. So in conclusion, so we as a group also collectively agreed that Malaysia is a country which is in desperate need of changes in terms of allowing the citizens the right to freedom of liberty and expression, because most of us are still prohibited from sharing our thought or mind. And it is very depressing for us to live in a country where the government abuses its power and forces silence upon us, the citizens. So a change has to be implemented where the citizens are given the freedom to express their honest thoughts and feelings. And that is all that we have to share for today. Thank you very much, Mr. Justin, for giving us this opportunity to present. And we hope you understand whatever information that we've shared with you. Thank you.